Distinguished Chair, distinguished delegates, greetings from Brussels. In this video statement, I am pleased to bring to your attention the outcomes of the 16th meeting of the Task Force on Access to Justice. This meeting, the last one in the current intersessional period, was held in Geneva in the Palais des Nations on 17 and 18 of February 2025. The meeting brought together about 60 representatives of governments, the judiciary, non-governmental organizations, environmental lawyers, academia, international organizations, and other stakeholders. The meeting provided a valuable opportunity to learn about recent developments, good practices, and challenges in implementing the Convention's Access to Justice pillar through rich discussions and interventions from over 30 speakers. Experiences were shared by representatives of governments, supreme courts, independent review bodies, and other experts from Albania, Armenia, Austria, Bosnia and Herzegovina, European Commission, Greece, Guinea-Bissau, Iceland, Montenegro, Serbia, Spain, Ukraine, and the United Kingdom. Several public interest lawyers and representatives of NGOs presented these trends and shortcomings in access to justice to challenge decisions, acts, and omissions affecting the environment. Participants also learned about the work undertaken by and practice of the Special Rapporteur on the implication of human rights of the environmental sound management and disposal of hazardous substances and wastes. The United Nations Environmental Programme, the United Nations Development Programme, and the European Court of Human Rights. With this meeting, the task force completed its mandate as set out by Decision 7/3 adopted by the meeting of the parties. The thematic session of the meeting focused on access to justice in cases related to chemicals and wastes, water quality and noise pollution. The task force noted the continuous increase in the number of such cases initiated by environmental NGOs and other members of the public. Various challenges and possible solutions were identified in these areas with regard to standing, jurisdiction, limitation periods, timeliness and fairness of existing procedures, costs, burden of proof, access to relevant expertise, the use of scientific knowledge, and adequate and effective remedies, including injunctive relief. There is a clear need to continue to take necessary legislative and other measures to address these challenges, taking into account the close links between exposure to chemicals and wastes, noise and other pollution, their effects on the environment, human health, and the enjoyment of many human rights. The task force also took stock of recent and upcoming developments regarding the implementation of the third pillar of the Convention, particularly in relation to standing, scope of review, and remedies, including injunctive relief. The participants shared initiatives regarding and difficulties in providing legislative provisions related to access to justice for environmental NGOs and other members of the public to challenge decisions, acts, and omissions of private persons and public authorities violating laws relating to the environment. They also took note of additional barriers faced by children in this area. We learned about the approaches to carry out substantive and procedural review of decisions, acts, and omissions subject to the Convention. A number of specific remedies were discussed for environmental cases, including remediation, rehabilitation, limiting emissions, environmental monitoring, medical monitoring, funding for public environment awareness programs, instructions requiring omitted measures to be adopted, and suspensive effect of decisions or acts affecting the environment. The task force also explored several tools to promote effective access to justice, such as multi-stakeholder dialogues to remove existing barriers, dissemination of information on access to review procedures, collection of relevant data and statistics, and access to relevant case law using e-justice initiatives, modern digital technologies, and other tools, and also capacity building and specialization of the judiciary and other legal professionals and alternative dispute resolution methods. The task force encouraged parties in cooperation with stakeholders and partner organizations to extend e-justice initiatives to environmental cases and to promote public participation in the design, testing, and implementation of such initiatives. We also explored good practices and potential risks associated with the use of artificial intelligence and other modern digital tools in the development of e-justice systems. We also discussed how the establishment of multidisciplinary specialized teams and joint investigation teams for environmental cases could improve law enforcement, compliance, and damage assessment, including in a transboundary and international context. Overall, the task force meeting proved instrumental in sharing perspectives on current and emerging trends, as well as good practices in access to justice across various review procedures and jurisdictions. I encourage you to explore and use the wealth of materials now available on the meeting web page. However, the absence of remote participation arrangements and financial constraints significantly limited the ability of some parties, members of the judiciary, NGOs, and stakeholders to take part in the meeting. In conclusion, I would like to express my deep gratitude to all experts from parties, members of the judiciary, partner organizations, Aarhus Ecoforum, and other stakeholders who have supported the work of the task force in the current intersessional period, and I look forward to their support in the future. Thank you for your